My name is Darren Singa. I'm the managing attorney here at the Sul Lee Law Firm. And today, I'd like to talk to you a little bit about a crucial topic for anyone involved in construction projects. That is specifically lien interests of general contractors and subcontractors. New construction starts and major retrofit projects continue to be major boom areas in the economy here in Texas, especially North Texas. With them come legal issues and disputes amongst the owners, the general contractors, and the subcontractors. This can be caused by many different things. Fundamentally, there's always going to be some tension in the market between legacy companies and new entrants. You're also going to face tight deadlines as the economy continues to boom. Questions start to rise. You're going to see more disputes due to the complexity of projects. Projects have gone from basic buildings all the way to semiconductor plants, anywhere within that realm. And of course, as the economy starts to become unpredictable, you'll start to see increases in budget constraints, people insisting that things were included, people insisting that things are change orders, things like that. The net result of all of these things is that companies need to know what their lien rights are so that they can evaluate what leverage they have over the other parties. The three most common causes of disputes between general contractors and subcontractors, for example, can be boiled down to payment and budget issues. When was someone supposed to get paid relative to the work that was supposed to be prosecuted? The quality of work. This has to do with the standards to which the subcontractor is holding their company out to. What are the applicable regulations? What are the applicable industry standards? What is specified in the contract, as well as the specifications that are made part of it? And finally, the next issue is delays. If the project is delayed, is that owing to a subcontractor failing to secure their section of work appropriately? Was the project appropriately made ready for the subcontractor to start? Did someone issue a proceed with work notice? Did someone fail to make the condition ready for operation? Sometimes it's as simple as someone failed to secure or allow a delivery of critical materials. Those kinds of things go into delay, which then go into payment, which can cause an entire cascade. When there's legal disputes, one of the things that our clients are always asking us is, well, what are the ways in which this could have been avoided? And just like everything else, there boils down to basically three things. The first is pretty commonsensical. Build a good and clear relationship with your counterparty, whether that's a general contractor to the owner, the sub to the general, or the sub to his various different levels of sub-subs. Clear relationships, clear communication help tremendously. Second is all the parties ought to have good contracts that clearly spell out what their duties and obligations are, where one party's responsibility stops and where the other party's responsibility starts. That clarity in contract is one of the easiest ways to avoid everyone shrugging their shoulders and saying, I thought you had it in the middle of the project. Along with that, the third element is probably contract review. That is, once you've sketched these things out at a technical level and had a vision even at a business level, get legal involved. It's a good way to make sure that the way you're seeing the agreement is the way a court might see it, and therefore the way that you can get the other parties to see it. So that contract review by an attorney fits into the overall scheme of your project. Technical people need to be on board, your business folks need to be involved, and legal is the third part of the stool to make things stand up.